Welcome to another episode of Husch Blackwell's False Claims Act Insights podcast. I'm your host, Jonathan Porter. Last month was the 5-year anniversary of the beginning of the COVID-19 pandemic. I saw a slew of friends post online about what they were doing in the early days of COVID. Empty grocery store shelves, social distancing, toilet paper hoarding. You toilet paper hoarders, you know who you are. Recalling the early days of the pandemic has been kind of a weird retrospective for all of us, I think. But something else happened in the early days of COVID that impacts False Claims Act enforcement even still today, and that's the CARES Act. Today, we're commemorating the 5-year anniversary of the start of one of the most abused laws ever, the CARES Act. The CARES Act was the federal government's $2 trillion response to the COVID-19 pandemic, and almost from the beginning, the CARES Act got ripped off. I was still a federal prosecutor when the CARES Act was passed, and I remember talking with colleagues and FBI agents about posts on social media telling people just how easy COVID fraud was, and boy, was it. People have tried to estimate how much fraud there was, and I don't know which methodology to use, but it's safe to say that CARES Act fraud was substantial and possibly the biggest fraud in the history of federal programs. It was huge. Now, most of the enforcement on COVID fraud has been criminal, and rightly so. But the False Claims Act has made a surprisingly strong appearance in COVID fraud enforcement over the last several years, and in some pretty interesting ways. And so today, on this 5-year anniversary of the beginnings of COVID fraud, we're exploring how whistleblowers and the Justice Department are using the False Claims Act to address COVID fraud. Joining me to talk about COVID fraud enforcement under the False Claims Act is my colleague, Bob Peabody. Bob is a white-collar lawyer in Husch Blackwell's Boston office. He spent 15 years as a prosecutor, both state and federal, and Bob draws on that hefty background to help our clients with all types of government investigations, including False Claims Act investigations. Now, before embarking on a career in law, Bob was an award-winning member of the Harvard University football team where he played offensive tackle. But Bob, in preparing to have you on the podcast today, I did a little research, and I saw that in Harvard's 1976 team football roster, you were listed at 6'4", 193 pounds. And Bob, offensive tackles, they have gotten a lot bigger since those days. But no, Bob, seriously, I'm thrilled to have you on our team now, and I'm grateful that you've joined the podcast today. I'm looking forward to you telling our listeners a little bit about COVID fraud and the False Claims Act.
Well, thank you, Jonathan. I appreciate the invitation. I've got to know you over the last 2 years since you've been at Husch Blackwell. We've worked a very complex case together, and I really got to be good friends. So I'm honored to be on your very august podcast. It must have been a misprint, the program. I was 297. I was 227 pounds, which is a figure I try to keep at as best I can. Mostly I can, but we were small. We were much smaller tackles and guards back in those days. My son played college football, Division III. He was 300 pounds. But 197, I had to find that, keep that from my scrapbook. In any event, I'm pleased to be here, and your topic is obviously good interest to me. I remember when COVID hit and we were all locked down immediately after March 20th or so. And I was trying to figure out ways to keep myself busy. And so as I learned more and more about the CARES Act and the $2.2 trillion over time that was processed by the Congress, it struck me the same as struck you. This is going to be ripe with fraud. Heavens to Betsy.
So, Bob, as I said in the open, the vast majority of COVID fraud was truly criminal. At DOJ, I prosecuted some egregious COVID fraud. People who just faked bank records and tax returns to trick SBA and banks into large loans that they blew on insane stuff. I prosecuted accountants who did this, a pastor who invented a business to buy himself a Mercedes, an attorney who invented a string of fake businesses, and a guy who used a fake business to buy an expensive Pokemon card. The media liked that one. But those are all very, very criminal acts. So, Bob, with all that blatantly criminal conduct, tell us why we're talking about COVID fraud in the context of the False Claims Act today. Why is a civil remedy being used to combat criminal conduct?
Well, Jonathan, with $2.2 trillion worth of CARES Act subsidies that went across the country in a number of different categories, not just the Paycheck Protection Program, but bailing out large corporations and healthcare and hospitals. The False Claims Act is obviously an effective way to recoup those overages, those excesses, those fraudulent, not necessarily criminal fraudulent, but civil fraudulent excesses that people did to try to obtain more and more funds to keep their companies or their entities alive. And the False Claims Act provides a very straightforward and useful processes to investigate and then to sue under civil litigation practices. It can be used to prosecute, or I should say, to litigate against civil offenders. There are criminal aspects to it as well, but it's easier to do that way because the burden of proof is less. It's a preponderance of the evidence, 5149. And it's really about to recover funds, not to send people to jail or to send fines and so forth. So it's a very effective way to going after this enormous fraud that the criminal process did a share of, but now the civil aspect under the False Claims Act will really recover a great deal. As you know, it dates back to the Civil War. Abe Lincoln, Congress imposed the False Claims Act because they were upset with armament companies overcharging the federal government for bullets and cannons and things like that, and wanted to recoup the balances. And it was very successful. It's been in effect, although it's expanded and evolved over time. One of the factors that we deal with as litigators is the whole whistleblower or the key tam portion of it, which basically allows civilians, whether they're in a company or outside a company, if they're aware of fraud, overcharging the government for benefits or for whatever the case may be, overcharging for bullets and things like that, they can blow the whistle, which the federal government will then absorb, perhaps, and pursue the litigation on their behalf. The government is pleased with this whistleblower protection because they've sort of tripled or quadrupled their investigators. These hidden, watchdogs and truth tellers in the company, they bring fraud to the government's attention, which the government would not know necessarily through their own investigators. So it's really expanded and grown. And of course, there's a huge financial incentive for whistleblowers to bring these to the government's attention. And the process is they must bring the action. They file suit. They, the whistleblower, with the assistance of counsel. The government reviews it. It's all filed under seal. The government reviews it carefully. If they want to adopt it and take the case on themselves, which every whistleblower pines for, then they'll do so. But they also can refuse it, allowing the whistleblower themselves to litigate the case themselves. But the government remains involved in the whole process, overseeing what the civil litigants are doing, or if the case of adoption, pursuing it themselves. And the sanctions and the damages are significant. Every violation of the False Claim Act, every signature on every bill or invoice submitted to the government is an actionable amount that can bring $30,000 to $40,000 per violation, as well as additional fines and restitution. So it's very effective and very onerous and very punitive of those people that violate it. Last year, the DOJ saw more than $2.2 billion in false claims judgments and settlements, actually in 2022, and $1.9 billion of that, really the large majority, was whistleblower complaints. And as I said, it's an incentive for whistleblowers to bring these cases because they can recover between 15 and 30% of what the government requires. There are also parallel proceedings. The government can just as easily bring a criminal case along with a civil key tam case, and that happens a lot. Woe the poor defendant that has to battle both a civil case and a criminal indictment. It usually ends badly. But you've mentioned that some of the U.S. Attorney's offices, rather than doing full-blown investigations and full-blown key tams, they're using the False Claims Act to investigate and file suit against much smaller dollar COVID fraudsters. And in places like the Northern District of Mississippi, that U.S. Attorney's Office has sued hundreds of COVID loan recipients, and in fact won most of the cases because many of the recipients still want to litigate, enter a default judgment, and then it's up to the government to go recover whatever assets they have, buildings, houses, cars, widgets. But that's another way for the government has actually been successful in trying to recoup every last penny they can find that's been defrauded under the CARES Act.
Thanks, Bob. So I remember in the early days of COVID, those of us who were doing these cases talking and saying, hey, we're not going to touch a small fraction of this with criminal cases. And we were talking about, what are we supposed to do here? We don't have the manpower to indict everyone who committed COVID fraud. And it's interesting that you have U.S. Attorney's offices like the Northern District of Mississippi who came up with a sort of a clever way of tackling this issue by suing the small dollar ones, by investigating the big ones criminally and then suing the small dollar ones. And like you said, Bob, a lot of these are ending in default judgments because the last thing you want to do is say, no, I didn't commit COVID fraud. You sit for a deposition. All of a sudden, boom, you've admitted to faking tax documents and bank records and backdating stuff. So, yeah, it's an interesting thing. It really hasn't caught on, though. I think you see a handful of those truly criminal cases being brought under the False Claims Act, but I think a lot of small dollar blatant fraud is just not going to be prosecuted, and it's not going to be handled in any way by DOJ, which has been really interesting. But Bob, in addition to blatantly criminal conduct being identified in key TAMs or, DOJ using the FCA to get judgments in these small dollar code fraud cases, DOJ has also started getting settlements against loan recipients where the conduct is more borderline criminal. In recent months, we've seen FCA complaints filed against companies that have made misleading statements on their COVID loan applications. An example there is a recent FCA complaint that DOJ just filed against a Virginia lobbyist. For whatever reason, when Congress created these COVID loans, it said that lobbyists could not get loans. So there's a question on PPP and idle applications about whether you're engaged in lobbying activities. Well, this Virginia lobbyist disclosed being a lobbyist and was denied a loan, but then applied again, and this time represented itself as a public affairs business, not a lobbyist, public affairs. And DOJ seems to have foregone criminal action on that one, but instead they filed a complaint in federal court under the False Claims Act. So, Bob, tell our listeners about those types of misrepresentation cases that we're seeing brought under the False Claims Act.
Well, in that case, the lobbyist case that you mentioned, I believe that was a Paycheck Protection Program, a PPP proceeding. And many of our viewers, particularly if you were in business, probably obtained PPP loans. Everybody did, because it was a way, especially if you were a smaller company, to survive, at least the beginning of COVID, for several months. There was $350 billion authorized in the beginning and another $250 later on in 2020. So it was a lot of money went forward to keep businesses afloat and employees paid. And much like the cases we discussed before, the government has a right to pursue a criminal case or a civil case. But frankly, it's easier, as we discussed before, to bring civil actions. U.S. attorneys' offices and the DOJ have civil offices too, with many good lawyers in there. They can sue and bring those cases with a lot less heartache and stress and strain. I think in the lobbyist case, clearly there's a sense of mens rea there that he was trying to work around it. He was told no once, and then he just refashioned himself as another entity. And I think there was probably a pretty good criminal case there that he was a liar, and then you could prove it. But the resources are greater. They're much, much greater to pursue, and the chances of victory or success at trial are harder to obtain. So I can see why they decided to pursue it as a civil enforcement action. I think there's probably a pretty good defense, if I was his lawyer or her lawyer, that she goofed or he goofed. He just thought that he's prepared the application incorrectly, and since he was in public affairs, my fault. That's not going to get you a conviction. But it probably gets a settlement and money returned. I'm not sure in that case whether you actually received the funds. Probably did, otherwise they wouldn't be pursuing it. But you have to pay it back, obviously with interest. As I said before, DOJ does prefer civil enforcement actions based on the burden of proof and the ability to get resolution. And most civil cases do settle. They just do. As criminal lawyers, you and I, always say that they're plenty good civil litigators, but they're better criminal litigators because they have more experience in their past as prosecutors and then as the defense attorneys. In a civil case, you could also, even if there was a defense of I didn't know what I was doing, you could get instructions to the jury of reckless disregard for the truth, or what I would also call the willful blindness, ostrich in the sand, which requires that the defendant can be viewed as actually having the appropriate knowledge if they deliberately avoided learning the truth, in other words, head in the sand and turned the other way, or they believed a fact that existed and took actions to avoid learning about it. So it's right there in front of them. I've never done a case with willful blindness, but I think it would be very interesting to do it because the jury would be sort of scratching and go, well, of course you knew. So that would be a very effective tool to litigate or civilly enforce someone like that. You had raised with me this whole question about a Michigan company known as YAPP. They were a fuel systems company to the automotive industry, and they got a fairly significant loan of almost $10 million back in 2021. But once the due diligence and the audit proceedings took place, because once all this money came out, most of those loans were forgiven. But the larger ones, the Treasury Department and Small Business Administration actually looked into to audit them to see whether, in fact, they really were entitled. And they found that the company was owned by a company in the People's Republic of China. And that's not necessarily Nix's PPP loan, but it is a problem if, in fact, it's a large company that exceeds 500 employees and things like that. And YAP did. So they had to return those funds, I believe, in the course of the prosecution. Now, in fact, they settled for $14 million with DOJ. But it was a civil proceeding. Again, easier to win, easier to settle, easier to resolve, less manpower, less expense. And I think that's why it makes the FCA so potent is that the evildoers can be prosecuted criminally, but those that just took the money and either unknowingly or unwittingly and didn't deserve it have to give it back. But, this raises the good question, I think, for businessmen and businesswomen out there who run companies. Back in those days when people were applying, and I worked for a different firm at that time that represented a lot of companies, the confusion and the chaos and how to fill out the applications. And did they have cash reserves that may disqualify them? Did they not? And was the cash reserves part of the principal, et cetera, et cetera? So, but anytime you get a lawyer involved, and we were writing these applications, there's some defense and protection if the government says you did it wrong. So that's certainly an important part of PPP then, and frankly now, if you're being audited.
Yeah, absolutely, Bob. I love that you brought up reckless disregard. To me, reckless disregard is one of the most interesting facets of the False Claims Act. It's one thing to say that you knew that you were committing fraud. It's another thing to say, hey, you were aware of a substantial likelihood that something here was amiss and you just chose to ignore it. And that was reckless on your part. It's essentially saying, hey, jury, we want you to try to second guess what was going on here. And that's not available in criminal cases, as you said. But in the FCA, it's sort of asking the jury, hey, why don't you figure out, would you have done something differently? And that's a really interesting concept that I don't know that the authors of the original False Claims Act knew that that's what was going to eventually happen. But it really opens the door up to a lot of cases being brought under the False Claims Act that couldn't be brought criminally because of the standards there and the very different knowledge instruction. So it's really interesting. Yeah, Bob, I think you're seeing a bunch of cases that are going to be brought under the False Claims Act where it's sort of questionable as to whether the representations made on these applications were actually truthful. I wrote recently about an Idaho home health agency that got a PPP loan. In the PPP loan, it certified that it was not committing any federal or state crimes. And then a couple of years later, they get investigated for making false claims to Idaho's Medicaid program. And so they settle with Idaho's Medicaid program. They actually entered a plea to Medicaid fraud. But then DOJ has now gone back and filed a False Claims Act complaint against the health agency saying, well, look at that. You said that you weren't committing any crimes. And 2 years after you did that, you pled to a crime that covered that time period. And so now all of those PPP loans that were forgiven, those have got to come back. And so that's how a small problem becomes a really big problem under the False Claims Act because of these representations that you made when you're getting these PPP loans. It's just really, really interesting. So moving forward a bit, Bob, as we mentioned before, last year's DOJ FCA statistics, they showed a record number of key TAMs and COVID fraud key TAMs. That's a big portion of those record numbers. But while most key TAMs are filed by insiders blowing the whistle on fraud, some of these new COVID fraud key TAMs are being filed by data mining companies. My friend Jason Marcus has had success in this area, filing key TAMs for relators that are data mining companies that can dig through publicly available data to spot PPP fraud. Bob, this is a big change in how FCA works. It's probably not something that Congress saw coming when it passed the False Claims Act way back after the Civil War, but it is seeing results with these data mining companies. So, Bob, what are your thoughts about this trend of data mining companies filing key TAMs?
Well, obviously, there's so much money involved. You go back to $2.2 trillion. There's a lot of money to work with for the government to recover, for whistleblowers to participate in that recovery. And now you've mentioned the data mining third-party vendors, so to speak, who are there to profit as well. So there's a lot of incentive to pursue these cases, a significant incentive. I'm of two minds of this. Maybe it's because I have gray hair, I'm older. But on one hand, obviously this is good for the government. You've got more eyes looking at fraud with all these various subsidies, not just CARES Act, but all kinds of subsidies, contracts, financing under the federal subsidies for, you name it, healthcare, military, and the like. But you've got all these eyes looking at that. And so you've tripled your insiders, so to speak. These data mining companies, I'm not sure exactly how they work, whether they find the whistleblower finds them, or they find a whistleblower after they've identified the fraud, really doesn't matter. But it generates more investigations, both civil and criminal. Certainly increases the recoveries that the government's going to make. It couldn't identify, as I was alluding to, a broader class of fraudsters out there. And it probably serves to incentivize companies not to get involved in false claims submissions, just the fact that everyone's looking. the government, the insider whistleblowers, and the outsiders. But on the other hand, and this is obviously maybe it's my age side, I don't like the concept of bounty hunters. They're bounty hunters. They're looking for pelts, up in the northern Canada. They're searching for potential fraud, and they're likely to settle on fraud that isn't fraud or do whatever they can to get in under the door, much like a relator whistleblower wants the government to adopt their case. And what is their technology? Perhaps it's sophisticated, perhaps it's not. And who are these companies? You mentioned your friend. I'm sure he's a fine, upstanding man. But who else is out there doing it? Believe me, that it's like the financial investment business. There are too many people who know what they're doing or pursuing that. So is their technology verifiable? Is it trustworthy? I would think the government would be circumspect in vetting these kinds of leads. So that's just my view.
Thanks, Bob. Yeah, I get the two minds. I think no one is in favor of government fraud. We on the defense side, that doesn't mean we're pro-fraud. We're anti-fraud. And so in general, steps to avoid fraud is good. But I also don't know that a data mining company is exactly the right person to be bringing these cases. In theory, look at how large our federal government is. You would hope that they would have data mining programs within the federal government to catch fraud like this. But I guess they don't, or it's not as effective as these companies that are being run and then turning into whistleblowing companies, which is just an interesting, hopefully there are smarter people than me who are out there trying to figure out, is this something that we really want the False Claims Act to become? Because I think that this could be replicated in other industries where all of a sudden you've got data mining companies that are saying, well, we think that this hospital is upcoding something or this defense contractor is doing X or Y wrong. That I think would be an interesting trend that other people should figure out. Is this what we really want or not? So, Bob, when we were first realizing the enormous amount of fraud involved in PPP, one of the things that struck me was that the financial institutions that processed PPPs could end up with big False Claims Act problems. And that, to me, is a big, important concept that I want to make sure that we cover in this episode. So the way Congress set up PPP, financial institutions were the first line of defense. Banks processed the loans as they do many other types of SBA loans. And the question was, to what degree should the banks have caught a lot of these fraudulent loans? And that was just theory for several years until recently, when DOJ started taking action against PPP lenders. The most notable action to me was a few months back when DOJ intervened in a qui tam against one of the biggest PPP lenders, a financial company called Cabbage. According to the complaints, Cabbage caused the submission of false claims through maintaining inadequate fraud prevention controls. But Bob, Cabbage is just one of many, many banks that processed PPP loans. What do you make of an FCA case against banks for failing to catch PPP fraud? And what should other banks that could have these investigations coming be thinking about future enforcement?
Well, I remember back in 20, I have a number of friends, I'm sure you do too, who are small businessmen. And it was their bankers that informed them of these PPP subsidies that are coming down the pike. And a particularly close friend who runs a furniture and textile business immediately leapt onto that and put it together. And he relied on his local bank, the bank that lends him money for businesses, to do it all for him. He didn't get a lawyer. He just did it himself and relied on the bank officer to sort of walk him through the application. And I think in most cases back then, those banks were drinking through fire hoses. They were deputized to do the application process for grants that they don't normally deal with. They deal with commercial loans for capital expansion, things like that. So the onus is obviously on the who's receiving the loan. In this case, they were just a conduit of the government to help get funds to these companies. It was a natural place to go. The banks, because obviously are facile with finances and things of that nature. My sense was that they were as confused as everybody else. They were drinking through the fire hoses and trying to process this as quickly as possible because people needed these subsidies ASAP for obvious reasons. And April, May, June, July of 2020 was just, they were inundated, as I mentioned before. And I think negligence on their part for not catching this or catching that or being aware. And by the way, the rules were changing too. It was moving the goalposts, as they say. Qualifications, forgiveness, responsibilities, definitions of what costs, because you could apply cost of mortgage, cost of 401ks, taxes. They were all changing at the time. And I think people were hugely confused. So I think if I'm the government enforcing this, I want to look about the good faith of both the bank and the individual I probably wouldn't pursue it. But as time wore on, people, the goalposts stopped. The rules were clear. And I think PPP went on for several months, even into late 20 and early 21, until it stopped. And I think by that point, if people were committing fraud and careless, then, they have hell to pay for that. Your Cabbage example, actually, Cabbage was a subsidiary of American Express. They had a fancy name for it later, K Ventures or K Finance or something like that. But you're right, it was massive. But the facts, as I read them, showed a lot more sort of deviousness on their part to process. It reminds me of countrywide loans during the mortgage crisis. Anybody came in would get a loan, no document, no nothing. This wasn't dissimilar to that. They inflated loans for people, according to one of the articles I read, where they really weren't entitled to those large amounts. This was really on Cabbage side. They acknowledged they double counted to the state and expenses just to get the loan bigger because their commission or their fee obviously could be bigger. They didn't stick to the $100,000 per employee limits because PPP wasn't funding people for years. It was just a short stopgap. Same with leave and severance. They were cooking the numbers on that. And they were aware of errors. They were aware of what they were doing as early as April of 2020. So they actually were more sophisticated than perhaps your local bank was. They removed underwriting steps. They set substandard fraud check thresholds. This is Cabbage. They used automated tools that were inadequate. I mean, it was a mess. It was a stew of confusion and chaos and fraud. They were fortunate enough to be able to resolve their case civilly, even though it seems like a pretty good criminal case to me. I think one of the reasons they did it because they're bankrupt and went under. And the best the government could get from that, I think my memory is they received $121 million as a creditor in the bankruptcy. So, wait your turn to see if you get any money back from it. And I think that's why they moved. And I suspect Cabbage resolved this very quickly once it was understood since they were going under anyway. But these were key TAMs. Actually, I noticed that one of the key TAMs was one of the whistleblowers who was from Massachusetts and the other was from Texas. And they shared, well, I'm not sure what they shared. There was no funds at the end of that. But nonetheless, those kinds of cases, I think, are attractive to pursue civilly or criminally. But I would leave the community banker at Lynn Bank and Trust alone, particularly if they didn't know what they were doing.
Thanks, Bob. Yeah, it's interesting. And we could do a whole other podcast on exactly what happened at Cabbage. What's interesting is a few months back, as you said, there are a lot of key TAMs against Cabbage. But what's interesting is there are still key TAMs that are going forward against Cabbage's former executives. And that's a really interesting concept is, Cabbage is now bankrupt, but the executives are still fighting these key TAMs. I think DOJ actually joined in one of those key TAMs against the former Cabbage executives late last year. And so these are still moving forward. It's really interesting. Bob, to me, what's interesting is, yes, we're talking about all the accusations against Cabbage, but I could say the same thing about the SBA. So the SBA administered the economic injury disaster loans. That was something that did not involve banks. That was a direct to SBA program, also under the CARES Act. And I can tell you, SBA just did not do a good job of vetting those idle applications. They got ripped off, just as hard as the banks did. I recall sitting down with federal agents where we're looking at these cases, figuring out which ones to charge, which ones to investigate more, which ones to try to focus our attention in, and seeing that there were a bunch of these idle loans that SBA had the answer in front of them. They still approved it. SBA would ask for backup documents to verify that they had the revenue amounts. So they'd ask for their tax returns. And people would upload their real tax returns that showed they made no money. And yet still the SBA officers are approving all of these huge loans. And so to me, it's a little interesting where this concept of we're going to hold the banks responsible for all of this fraud. And yet SBA itself did the exact same thing for other programs. I think ultimately, when we're talking about CARES Act enforcement, we should be a little humble here and just say, look, the government was pushing out money as quickly as possible. That was the directive from Congress. The banks were doing the same thing. Just because it could have been done better, that doesn't mean that it was fraud in the first instance. And so to me, I would hope that people who are thinking who should pay the price for COVID fraud, let's think carefully about what SBA could have done better and whether we want to hold other people to a higher standard than what we're holding SBA to. So that's my own personal opinion there. So Bob, I think a lesson in all of these cases is, one, enforcement in this area is still coming. And two, There are a lot of ways to slip up in terms of eligibility where you could have issues under the False Claims Act. And I know we've covered a few, but there are a lot more. You mentioned companies with common owners, companies that have affiliates where you ought to have combined the revenue to determine eligibility. There's so many other ways you could mess up here. So, Bob, if companies have concerns over whether they were eligible to get these loans in the first place, what should they be thinking about here? Close us out with some guidance on that front.
Well, it's a self-serving comment, but if you're a business and you have a budget for business expenses, you should hire a lawyer, or you should go to your current lawyer, whether you be your business lawyer, whether it be your tax lawyer, whether it be a lending lawyer, and raise these concerns now since they're in the public eye and the front pages of newspapers, and revisit perhaps the millions of dollars that you recovered or received from the PPP program or other CARES Act programs for that matter. See whether we did it right. And you really can't do that without competent counsel to advise you in those categories. Even white collar lawyers like us who just know how the government thinks and what they'll be looking for and what the hotspots would be very useful to do as well. And review your applications and review the funds coming in and review how long you received them and who received them. The government will inevitably come and audit you if you receive a lot of money through these programs. It takes time because they only have so many people doing the audits, but they will come, they will find you, and you better be prepared to respond accordingly. And if there are issues that maybe you could have fixed or were wrong, this is really a ripe opportunity to, in some instances, self-report. I would say self-reporting is a very productive thing. You come to the government and say, mea culpa, and they always tend to deal with you, particularly if your lawyer present with you, they tend to deal with you a little bit more benignly. But just for your own peace of mind, since all this money, as you said, was pushed out the door back 5 years ago, and the largest subsidy program in the history of the world, the government is not going to go lightly because they can recover a lot. And they have recovered a lot. So contact your lawyer, sit down with him or her, sort through these issues, get ahead of it, always get ahead of the government. This is an adage a former agent used to tell me, turned investigator, get ahead of the government and determine as you navigate the whole false claim, key TAM, COVID relief landscape that you're aware that it's fraught with peril.
Thanks, Bob. Yeah, that is the advice is if you think you've got these issues, always get ahead of it. The way DOJ and a judge and a jury is going to be different if you sort of self-disclose. If you come forward, you make it right yourself. That's always going to be different. That's not to say that you can fix an investigation problem by just self-disclosing. I prosecuted one attorney who committed COVID fraud. And after FBI showed up at her door, she all of a sudden paid all of the money back and said, well, see, you can't prosecute me now because I paid it back. It doesn't work like that. But still, if you repay before DOJ or FBI comes knocking, I think that's going to be a tremendous credit to you. And so, Bob, your advice is excellent. Get ahead of any issues you may have. Call a lawyer and just understand there are ways for you to mitigate things that were not done well in the past. And so, Bob, your guidance there is spot on. And Bob, I appreciate you coming on the podcast and offering your expertise to folks who may think they have some issues with the CARES Act.
Thank you.
To close us out, as Bob mentioned, there were a record number of key TAMs filed last year. DOJ's data shows that a lot of those were in the PPP or idle world. And so key TAMs filed last year, those investigations are happening this year. And so, as Bob said, now's a good time for you to sort of figure out, did I do something wrong and can I get ahead of it? Because I don't think that these cases are stopping now. Congress amended the statute of limitations for COVID fraud from 5 years to 10 years. And so these cases are going to continue to be investigated. They're going to be there for a while. You just running out the clock, that's a bad strategy because there's 5 more years on the statute of limitations for COVID fraud. And so you getting ahead of this is a good idea. I would recommend getting ahead of any sort of issues that you have and not sitting there for the next 5 years hoping that you don't get caught. Call a lawyer now and figure out whether you've done something right or wrong. And so that's our conversation for today. We're going to continue to bring you cases like this or episodes like this where we're going to talk about how the False Claims Act is being used in new and interesting ways. And so however you're listening to this, you can subscribe, whatever you want to do to continue listening to us. But we appreciate all of our listeners. We hope you appreciated this discussion of COVID fraud. We appreciate you listening, and we'll see you next time.